Thank you for both counsel. Now I will give you my decision alongside with my clarifications. So the issue that we have before the tribunal today is the delivery of the palm oil products by the respondents. So we have to know that in order to sustain the claim, the claimant must demonstrate that there is a contract between the respondents and the claimant, and the respondent breached the sales contract, which in this case the claimant has clearly and explicitly stated that the respondent is not following the sales contract in failing to deliver the palm oil products to the claimant. So additionally, in the tribunal's view relating to this issue, the claim is a straightforward claim breaching of contract in the part of the respondents, and in this tribunal view, the respondent has failed to provide the contrary. So we decided that we release the final award on the part of the claimant and dismiss all the claims made by the respondents, and the awards are the sum $2,261,100 to respondent to be paid to the claimant, and we also ordered the respondent to pay legal fees and arbitral expenses in the cost of $5,000. Hence, please submit your submission to the tribunal for further actions. That's all for today's proceedings. We shall adjourn. Okay, we decided that we release the final award on the part of the claimant and dismiss all the claims made by respondents, and the awards are the sum $1,374,200 to the respondents to be paid to the claimant, and we also ordered the respondent to pay legal fees and arbitral expenses in the cost of ringgit. Hence, please submit your submission to the tribunal for further actions. And that's all for this proceeding. We shall adjourn.
My lord, if it please this honorable court, I am Alia Atiqah, the counsel representing Ajwa for Food Industry Company, the appellant. Together assisting the court in the present case is Noraishah Humaira. My lord, I have one count of contention to present in my submission today. My ground of the contention is that the State Foreign Tribunal has no jurisdiction to hear the arbitration case in question due to no agreement entered between the parties to arbitrate their disputes, as available under Section 37 of the Arbitration Act 2005. I shall require 10 minutes of the court's time for my submission. My lord, I will proceed to the brief statement of facts. This case is an appeal of the High Court's decision upholding two awards ruled by the Arbitration Tribunal in favour of the respondent. The appellant now requested of appeal to set aside both arbitral awards made by the Arbitration Tribunal under the Section 37 of the ground that no proper notice of the STC was given to the appellant when the contracts were entered into. In the instance case, the appellant had failed to take delivery of palm oil products ordered from the respondent, resulting in the respondent initiating two arbitration proceedings against the appellant. The Arbitration Tribunal in giving awards in favour of the respondent, i.e. the damages in the sum of $2,261,100 and the $1,374,200, had assumed its jurisdiction based upon written sales contract between the parties incorporated with standard terms and conditions of sale (STC), which allegedly contained the arbitration clause by the respondent. My lord, I am now done with the statement of facts. If there are no preliminary questions from this court, I shall proceed with my submission.
Please.
My lord, Ajwa for Food Industry Company, the appellant respectfully submit that without a written arbitration agreement of the parties, the arbitrators have no jurisdiction to adjudicate the dispute. It is consistent with the court's conclusion in the case of Power, Malaysia Berhad and Dewan Corporation, where the court held that the agreement made by the parties to a dispute provides the basis for the arbitration's jurisdiction. Without such an agreement, there is no jurisdiction. As about for my contention, Section 9 of the Malaysian Arbitration Act 2005 affirms that written arbitration agreements are a prerequisite. The provision explains that the arbitration agreement must be in writing, and the writing requirement is satisfied if the arbitration agreement is in a document signed by the parties, or is in an exchange of letter, telex, facsimile, or other means of communication which provide for a record of the agreement. Therefore, my lord, in determining its own jurisdiction, in this case, the arbitral tribunal had to determine whether the respondent had met the burden of proving that the respondent and the appellant had reached an understanding regarding the process for resolving dispute between them. My lord, the appellant further submit that STC relied on the respondent to bring the arbitration proceeding against the appellant was not attached to the sales contract. Thus, I believe it is considered a separate document. There is no evidence that the STC is genuine or even contemporaneous document used in transaction. Furthermore, the STC or any other sort of documentary evidence demonstrating that the appellant was aware of and concurred with these particular terms in each transaction is not mentioned in front of the arbitration tribunal. Even worse, the appellant never received the STC. Apart from that, my lord, the respondent's so-called reference to the STC in the sales contract is ambiguous, by stating that all other terms, conditions, and rules not in contradiction with the above, as well as terms and conditions, it is insufficient to incorporate the STC into the sales contract. Unquestionably, this agreement is not clear-cut. Thus, the appellant cannot be said to have received any notice of STC. In accordance with this, STC cannot be regarded as having been added to the parties' agreement by reference, making it a part of it. Not to forget, my lord, the STC was unilaterally imposed by the respondent into the sales contract. When the sales contract was concluded, there was no agreement by the appellant to refer disputes to arbitration. More importantly, no agreement was made to accept any new conditions added to the STC after the contracts of sale were finalized. My lord, the appellant further contends that the arbitral tribunal's decision had been influenced by the appellants and respondents' over 20 years history of trade, as well as their prior practice of referring issues to forum arbitration. Taking this fact at the face value, the arbitral tribunal had erred in holding any arbitration agreement from a prior transaction to be enforceable in the present transaction. To conclude my ground of contention, my lord, I shall reiterate that the absence of agreement between the appellant and the respondent indicates a lack of jurisdiction of the arbitral tribunal in adjudicating the dispute. Therefore, I would like to pray before the court to set aside two arbitral awards made in favor of the respondent by the arbitral tribunal according to Section 37 of the Arbitration Act 2005. I thank the court for its time and indulgence.
Respondent.
Good evening, may it please the Honorable Court. My name is Noraishah Humaira, appearing as the senior counsel for our client, respondent company, Pacific Intermediate Berhad. My lord, I will be dealing with the issue within 6 minutes. In response to the plaintiff's submission to set aside the arbitral tribunal for a respective sum of $1,347,200 with costs of around 5,000 ringgit and $2,261,100 with costs of Rm 5,000 ringgit, there are one main issue to be submitted by the respondent in proving that the arbitral tribunal indeed has the jurisdiction, which will constitute a failure to appellant's application to set aside based on Section 37 of the Arbitration Act 2005, which is, we will submit that there is an arbitration agreement in the agreements. Hence, the arbitral tribunal has the jurisdiction and has the power to hear the arbitration, thus binding the awards. My Lord, we submit that there is an existence of arbitration agreement between the parties relying on the for-sales contract entered into by both of the parties. The standard terms and conditions (STC) of the respondent's contract in clause 31 reads, all disputes under the sales contract together with this STC shall be resolved amicably, but if the dispute cannot be resolved, then parties will opt for arbitration in Kuala Lumpur under Forum Rules of Arbitration and Appeal. All legal matters will govern and interpreted in accordance with the laws of Malaysia and subject to the exclusive jurisdiction of the Malaysian court in Kuala Lumpur. My Lord, therefore, appellant cannot come to this court to set aside the arbitral award, as the arbitral tribunal has the jurisdiction to hear the arbitration. An arbitration agreement is a requirement in Section 9, subsection 2 of the Arbitration Act 2005, which states that an arbitration agreement may be in the form of an arbitration clause, in an agreement, or in the form of a separate agreement. Further, in Section 9, subsection 5 further states that a reference in an agreement to a document containing an arbitration clause shall constitute an arbitration agreement, provided that the agreement is in writing and the reference is such as to make that clause part of the agreement. The law on the issue of an existence of an arbitration agreement is very clear and unambiguous, as stated in Section 9 of the Arbitration Act 2005. And in establishing that Clause 31 of the STC relates to the arbitration agreement, we rely on the four sales of contract, which, in each of the sales of the contract, just before the signature column, there is a clear express statement to the effect which states, all other terms, conditions, and rules do not in contradiction with the above as for plaintiff's terms and conditions. Hence, the arbitral tribunal is empowered to make these findings of facts. We affirm, therefore, the arbitral tribunal had correctly made the above findings based on relevant evidence and documents before it. Even in the Indian case of T.N. Rao and Balabhadra, the judge in this case ruled as follows. It is reasonable to hope when the parties had referred to a document which was in existence, they had knowledge, or what comes to the same thing, could have had knowledge of all the terms contained in that document, and an arbitration clause contained in that document must therefore be held to be binding on them exactly as if it had been incorporated in extenso in the signed contract. Before holding that the parties have agreed in writing to refer their dispute to arbitration, and in the absence of such clause in the agreement actually signed by the parties, there must be at least a specific contract or document containing such a clause in respect of which it might be said that it has been incorporated in the agreement of the parties by reference. In the present case, the respondent's standard terms and conditions were circulated to all buyers, and additional copies were made available to all their branch offices. The appellant, having bought from the respondent over a lengthy period of time, had full knowledge and had done business throughout on the basis of the said respondent's STCs. Therefore, the sales contract constitute the concluded contracts between the parties. The said STCs clearly referred to and incorporated there would be effective and binding upon the appellant regardless of its denial of having seen them. My Lord, this fails the application of the appellant to set aside the arbitral tribunal's award based on Section 37 of the Arbitration Act 2005. The Federal Court has laid down a well-settled principle in the case of Intellectual Sendirian Berhad and Future Heritage Sendirian Berhad that an arbitration award is final, binding, and conclusive, and can only be challenged in exceptional circumstances, which appellant failed to show in our case today. Your Excellency, is there any clarification needed for the first issue?
No.
Much obliged. Therefore, for the main issue, we submit that there is an arbitration agreement in the agreements. Hence, the arbitral tribunal has the jurisdiction to hear the case and has the power to hear the arbitration, and thus both of the awards are binding. We pray that the appellant's claim to be dismissed. Thank you, my Lord, for your time and indulgence.
Now I shall deliver my decisions. On the issue of the existence of the arbitration agreement between the parties, the law on the issue of an existence of an arbitration agreement is very clear and unambiguous. The relevant section is Section 9 of the Arbitration Act 2005. The Arbitration Tribunal held that it has the necessary jurisdiction to deal with the matter, as there was clearly an express agreement, as in Clause 31, to refer the dispute to an arbitration. So, if the dispute cannot be resolved, the matter will be brought to the arbitration process. Then the learned High Court judge affirmed this finding by the arbitration tribunal, and the learned High Court judge had clearly elaborated on this point that in the grounds of judgment to determine that the existence of arbitration agreement in section 9 clause 1 until 5 of the Arbitration Act need to be referred, and we fully agreed with the learned High Court judge on this point. And moreover, in establishing the clause 1 of the standard terms and conditions STC relates to the arbitration agreement, the respondent relied on 4 sales contract, and each of the sales contract just before the signature of column, there is a clear express statement to effect that all other terms, conditions and rules do not in contradiction with above as for plaintiff's terms and conditions as stated by the respondent. The appellant's contention said that clause 31 was never incorporated and it never had sight of the said standard terms and conditions. From the records and evidence available before us, we find that the arbitration tribunal has sufficiently considered this issue in coming to its decision in making the awards in favour of the respondent. To that effect, the arbitration tribunal has correctly made several findings of facts to support its findings based on the past practice and also the conduct of the parties. So we are in the view that arbitration tribunal is empowered to make these findings of facts. The learned High Court judge was correct in not interfering with these findings, and there is no evidence of miscarriage of justice or procedural impropriety to warrant interference. And at our level, we feel that there is no ground for us to interfere with these findings which had been affirmed by the High Court judge, and we affirm that the arbitration tribunal had correctly made the above findings based on the relevant evidence and documents before it. So on the second issue, which is to set aside the arbitration award, the section 37 1 of the Arbitration Act 2005 provides that for various grounds on which an arbitral award may be set aside. So the onus is on the party making the application to provide proof, and it is the court's discretion in setting aside the arbitral award. It's now limited and narrowly defined in the circumstances in line with the modern international arbitral practice. Moreover, the present section 9 and 37 of Arbitration Act 2005 is that the court should be slow in interfering with an arbitral award. The court should be restrained from interference unless it is a case patent injustice which the law permits in clear terms to intervene. And lastly, on the above considerations, we find that the appellant's ground of appeal to set aside or vary the Forum Arbitration Tribunal Award under Section 37 of the Arbitration Act 2005 are misconceived both in law and fact. We therefore dismiss both the appeals with cost of Rm 10,000 to the respondent for both appeals. We affirm the findings and decision of the learned High Court judge in both cases, and we also make an order that deposits in respect of both appeals be paid to the respondent on account of fixed costs. That's all.